How do you analyze an evidentiary search and seizure performed by the government under the Fourth Amendment on a criminal procedure essay? Well, remember, the Fourth Amendment protects against unreasonable government searches and seizures. In our last video, we talked about government seizures of a person. In today's video, we want to move on and talk about government searches and seizures of evidence to be used against a person in a criminal prosecution. And it's really important for our purposes on a criminal procedure essay to distinguish the difference here, right? The analysis is going to change depending on whether we're dealing with a government seizure of a person versus a government search and seizure of evidence to be used against a person. So before you jump into a Fourth Amendment analysis, make sure that you have the right category. Ask yourself, is this a seizure of a person or search and seizure of evidence, right? Today, we're talking about evidentiary searches and seizures under the Fourth Amendment. Okay, but moving on, our starting point rule for an evidentiary search and seizure under the Fourth Amendment is really straightforward. Absent an exception, an evidentiary search and seizure by the government without a warrant is unlawful. Recognize that this is very different from our discussion of a seizure of a person, right? Remember, we said for the government to seize a person, generally, there was not a warrant requirement. When we're talking about an evidentiary search and seizure, that flips. Our general starting point rule is that a warrant is required, okay? But so the first thing that we have to ask here under the Fourth Amendment, as always, right, if we're dealing with a Fourth Amendment analysis, is number one, was the search performed by a government agent? We have to have a government actor to trigger the Fourth Amendment. If we have a search and seizure of evidence, but the search is being performed by a private citizen, the Fourth Amendment is not at issue. This is a very common fact pattern. Imagine that you have an employer and employee relationship, right? The employer is rummaging through the employee's desk looking for something and finds drugs, so then he calls the police. The employee is going to want to raise, hey, my Fourth Amendment right was, violated here. This is an unreasonable search and seizure. Obviously, that's not going to work because the search and seizure is not being performed by the government. It's being performed by his boss. So that does not trigger the Fourth Amendment. So your first question has to be, was the search performed by a government agent? If it's not, remember, Fourth Amendment is not at issue, okay? So that should be relatively straightforward. Moving on to our second question in this evidentiary search and seizure analysis has to be defining what a Fourth Amendment search actually is. Because when we're talking about a Fourth Amendment search, we're not using the word search like a layman person might use the word search. Someone might say, I wake up in the morning and I search for my keys before I go to work, right? That might be the Webster Dictionary definition of search, but that's not how we're using it when we're talking about the Fourth Amendment. When we're talking about the Fourth Amendment, we define a search as a physical intrusion performed by the government into a constitutionally protected area. Constitutionally protected areas under the Fourth Amendment is going to include any area where you have a reasonable expectation of privacy, okay? So where do you have this reasonable expectation of privacy? The general starting point primary place is going to be a person's home and the curtilage surrounding that home, somebody's backyard, their home, any part of the property that's really being used for residential purposes where there's a reasonable expectation of privacy. It's going to be a constitutionally protected area. So in order for the government to physically intrude into that area, remember, under the Fourth Amendment, evidentiary searches and seizures, they have to have a search warrant to do so unless an exception applies, okay? So it's very important for us to recognize under the Fourth Amendment what a search actually is. Because if a police officer is just standing on the sidewalk, right, or in a public space and is looking around, imagine that a police officer is standing on the sidewalk and he's literally doing 360-degree turns. Everywhere that he's looking and seeing, he's not searching for Fourth Amendment purposes, right? He's not physically intruding into a person's constitutionally protected area. Looking from a public space is not anything that you're seeing, right? Is not violating a person's reasonable expectation of privacy. right? So imagine that a person is in their home conducting some sort of criminal activity. Maybe they're using drugs, manufacturing, controlled substances, who knows, right? But a police officer who's standing on the sidewalk and sees this happening through the window, that's not a search for Fourth Amendment purposes. This second question, whether the law enforcement officer violated that person's reasonable expectation of privacy, the answer is going to be no. So the Fourth Amendment is not at issue at that point in the analysis. No search has been conducted under the Fourth Amendment, right? So the general rule here is anything that is visible from a public space, public airspace or public space, public streets, public sidewalks, is not going to be constitutionally protected under the Fourth Amendment. You do not have a reasonable expectation of privacy if you are visible from a public space, public airspace, public space, even if you're in your home, even if you're in your backyard. If a police officer can see you from a public space, you do not have a reasonable expectation of privacy. So no Fourth Amendment search is being conducted. Okay, so what are more areas that courts have adjudicated a person has a reasonable expectation of privacy, these constitutionally protected areas under the Fourth Amendment? I usually think of the acronym HOL, H-H-O-L, HOL with two H's and no E at the end, right? H-H-O-L. The home, which you remember includes the backyard and the curtilage surrounding the home, hotel rooms, offices, and luggage. Those are going to be the big four places you want to think about in terms of constitutionally protected areas. For the government to physically intrude in any of those areas, they have to have a search warrant unless an exception applies, okay? Areas where you do not have a reasonable expectation of privacy are going to include abandoned property, right? If you take trash and you throw it away and that trash gets put out on that public street, remember, anything visible from a public space, that's not violating your reasonable expectation of privacy. So a police officer can rummage through your trash can if that trash can goes out into a public space, right? Abandoned property, anything that is visible from a public space, whether it's airspace or streets, sidewalks, whatever, all of that is going to not fall under reasonable expectation of privacy. That's not constitutionally protected, okay? What if a police officer, though, and this is a common fact pattern, is using some sort of sensory enhancing device? He has binoculars, he's looking through somebody's window with a camera lens with a deep magnification, or he's got binoculars or a flashlight, right? The rule is going to be if the equipment that that police officer is using is generally accessible and available to the public, that's fine. Police officer can do that. It's still not going to be a search for Fourth Amendment purposes. Now, if the police officer is using some sort of sensory enhancing equipment that is not available to the general public, the common example here is a heat sensor, I think it's called, heat scanners. The military uses them, and police, they can see through walls and show you where heat indexes are. So if a person is moving behind a wall, you can kind of follow their body temperature and heat, right? That kind of stuff is not available to the general public. So if a police officer is using that, that is going to constitute a physical intrusion into a constitutionally protected area, into a place where there's a reasonable expectation of privacy, because that type of equipment is not available to the general public, okay? So that's the main ideas here. Also, an important thing to recognize that's commonly tested is this idea of the open fields doctrine, right? Open fields are not constitutionally protected. A person does not have a reasonable expectation of privacy in an open field. Obviously, this is going to be more common in rural areas, farmland, places, Midwest, Southeast, I guess everywhere, right? There's rural areas everywhere, but anywhere where you have these big acres of land, wooded areas, dirt, it doesn't matter, right? Open fields are not constitutionally protected, even if there's a fence around them, right? If you have a white picket fence going around it or barbed wire fence, whatever, the police can actually step over that fence, even if it's private property, and come on it and look around with their flashlight. That's not a search for Fourth Amendment purposes. Remember, an open field is not constitutionally protected as a reasonable expectation of privacy. You do not have a reasonable expectation of privacy in an open field. So they can step over, they can come onto the property, they can shine the flashlights and look around. that's still not triggering the Fourth Amendment. But if that crosses and they come into a person's curtilage, their backyard, that they're actually using for residential purposes, now we're getting into a physical intrusion, right? And the difference between curtilage, somebody's backyard, and an open field can sometimes be hard, but it's going to be, making that distinction can sometimes be hard, but it's just going to be a totality of the circumstances. Think about what the purpose of the land is. Is it more for residential purposes, or is it more for non-residential purposes? Is it just dirt or agricultural, right? That's what you're going to want to think about primarily. Also, fences, right? People always get hung up on fences, so I hate to even bring it up, but fencing can be a factor, but it's not determinative, right? Remember, an open field can be surrounded by fences and privately owned, and police officers can come over that and look around without triggering the Fourth Amendment. That's not constitutionally protected. But the size of the fence, right, might be a factor too. Imagine a barbed wire fence that's very easy to see across and step over versus a 20-foot high concrete wall, right? There might be a higher reasonable expectation of privacy behind a 20-foot concrete wall versus a, little barbed wire fence. So again, it's very fact specific, very totality of the circumstances, but think about the reasonable expectation of privacy and the difference between a home and curtilage, residential purposes versus, just land, open fields, agricultural land that's being used for other purposes. Okay, so there is that distinction between the home and the curtilage and open fields, but remember, the main things you want to think about here are that acronym, HHOL. Home, hotel, office, and luggage. Those are all constitutionally protected areas. If the government is going to physically intrude into those areas, generally they need a warrant, obviously unless an exception applies, okay? So at this point in the analysis, if you've determined that you have a government agent, right, and he's physically intruding into a constitutionally protected area, you're ready to move on to number 3. Now, if your answer, though, to either of these questions is no, then the Fourth Amendment is not at issue. Remember, if we don't have a government agent, no Fourth Amendment issue. If the government's conduct is not physically intruding into a constitutionally protected area, then it's not really a search for Fourth Amendment purposes. Therefore, Fourth Amendment does not apply. Remember, Fourth Amendment protects against unreasonable searches and seizures performed by the government, right? So if we have no search, no violation of a person's reasonable expectation of privacy, then we have no search for Fourth Amendment purposes. Fourth Amendment is not at issue. But if your answer to both of these questions is yes, as it's drawn up here on the board, you can move on to number 3, this warrant requirement. You need to decide whether the government agent had a valid search warrant. This should be very straightforward, right? The fact pattern is going to tell you whether or not that law enforcement officer had a warrant or did not have a warrant. That's going to be given to you. What might be a little bit trickier is this idea of a valid search warrant, right? Generally, there's going to be 3 requirements for a search warrant to be valid. It has to be issued. Number 1, it has to be issued by a neutral magistrate. Number 2, it has to be based on a finding of probable cause. And number 3, it has to describe the items and location that's going to be searched and seized with reasonable specificity, okay? So issued by a neutral magistrate, that's pretty straightforward, right? Can't be someone like the state attorney general. We need a neutral magistrate, but it does have to be based on a finding of probable cause. And remember, we talked about this in our last video. Probable cause is more than a reasonable suspicion. Doesn't have to be 100% certainty, but it is more than a reasonable suspicion. We need articulable facts, right? Usually there's some sort of informant or witness that has some degree of credibility that's saying, hey, look, this item you want, this evidence is on this property. That's usually what's going to lead to it. Or they have some good articulable facts that suggest that the evidence that they want is going to be in this place, in this constitutionally protected area. And generally, the process here is going to be, you're going to have a police officer file an affidavit with the magistrate, and the magistrate is going to look over that affidavit. If there's probable cause, then they're going to grant that search warrant, then the police can go and execute that search warrant. However, if the defendant, the person who was being searched and seized against by the government, can argue that the search warrant was invalid if he can show falsehood, right? If that search warrant was based, again, 3 requirements, if that search warrant was based on a false statement, that statement was made by a law enforcement officer, either intentionally or recklessly, and that false statement was material in the judge's finding of probable cause, then that can be found to be an invalid search warrant. But those requirements are very strict. Defendant's going to have to show all 3 of those, that we have a false statement, that false statement was made recklessly or intentionally, and that false statement was material in the judge's finding of probable cause. But if you can show those 3 things, then the search warrant can be made invalid, right? Invalid search warrant, then you have to come over here and talk about exceptions, right? Now, the one kind of caveat here with this whole validity of the search warrant is if you have a situation where a police officer is executing a search warrant that is facially valid, right? The police officer believes that he's got a good by-the-book search warrant and he executes it and he goes out there and finds evidence. We're not going to exclude the evidence that's obtained. And we'll talk more about exclusionary rules in a later video, but it's worth noting right now, even if we have an invalid search warrant, but it appears facially valid and the officer executes that warrant properly and obtains evidence, that evidence is not going to be excluded, okay? So here, once you determine that you have all 3 of these, right? You have a government agent, you have him intruding. This government agent is physically intruding into a constitutionally protected area where the defendant has a reasonable expectation of privacy. He's got a valid search warrant to do this. There's only one question left, and that's going to be whether the execution of the warrant was proper. Okay, and again, there's going to be about generally three requirements here. Number one, the execution of the search warrant can't be an unreasonable delay from the time the warrant was issued. So it has to be timely, right? When the judge issues the warrant, there can't be an unreasonable delay from that time until the warrant is executed. The second general requirement is this idea of a knock and announce. Generally, police officers, before they execute a search warrant, have to knock and announce to let the occupant know, hey, we're coming in. This is why you always see this on TV shows and movies. Before the cops enter to execute a search warrant, they always bang on the door, right? And they're like, police, we have a warrant. That's why they have to knock and announce. Now, another caveat here is, exceptions to the exceptions. I know, guys, it's confusing, but if a knock and announce doesn't happen, similar to number 3 with this validity of the search warrant, just because the police failed to knock and announce, generally that is not going to make any evidence obtained excluded, right? So if the evidence is obtained but everything else is by the book, but they just failed to knock and announce, that evidence is generally not going to be excluded. So again, worth noting on a criminal procedure essay, hey, look, they're supposed to knock and announce. If they failed to, you just write that in your essay. Hey, look, a proper execution of a warrant, they should knock and announce, even though they failed to, that evidence is probably not going to be excluded. Okay, and then finally though, and the big requirement here, and what you really want to think about, right, is going to be the scope of the warrant. Remember, under number 3, when we said for the validity of the search warrant to apply, it had to describe the item and area to be searched and seized with specificity, right? The search warrant is going to have to, when the judge issues that, it's going to have to identify the areas to be searched and the items to be seized with specificity. And the police officers, when they're executing that warrant, can't go outside the scope of the warrant. So when they come in and they start looking around, if they have a search warrant to, who knows, to look for, let's say, a sawed-off shotgun, some large weapon, right? They have a search warrant that's identifying that this sawed-off shotgun is believed to have been used in a homicide, so they're trying to obtain this murder weapon. So they're searching the home for this piece of equipment, this weapon, a large sawed-off shotgun. They're not going to be able to look in tiny little drawers, right? Imagine a jewelry box on the nightstand or something. They can't open those little drawers looking for a sawed-off shotgun, right? That goes outside the scope of the warrant. Now, if they find illegal contraband while they're searching within the scope of the warrant, that's fine. But if they go outside of the scope of the warrant and find illegal contraband, that's going to be improper, and that's going to move over here. You have to ask if there's an exception, right? It's unlawful if the execution of the warrant is improper, okay? So to sum all of this up, I know this was a lot for a simple starting point rule. You have 4 questions to go through to get to a lawful search and seizure of evidence performed by the government, right? You have to ask whether we had that government agent or 2 starting point gateway issues, whether we had the government agent performing the search, whether that was a physical intrusion into a constitutionally protected area. If you have both of those things, remember, a warrant is going to be required. If we have these 2 things and no search warrant, then we have to come over here and talk about exceptions, right? Because absent an exception, that's unlawful. Then we have to ask, once we determine all 3 of these, whether the actual execution of the search warrant was proper. If all of these are satisfied, then that search and seizure of evidence performed by the government is lawful. Okay, now if either of these 2 are not satisfied, either the government agent does not have a warrant, the warrant is invalid, or the execution of the warrant is improper, the next question has to be whether there's a valid exception that search falls under that would allow it to still be lawful. We call this, there's an acronym, escapes from the search warrant requirement, and that's what we're going to talk about in our next video. But until then, guys, I wish you all the absolute best. I hope this was helpful, and I'll see you at our next video.